Okay, good afternoon, everyone. I'm very pleased to see you. I'm also very admiring of you because obviously today is a day where we have a transport strike in Berlin. So those of you who are here have maybe taken buses and S-Bahns and several other things. So we're very grateful that you could be here with us this afternoon. And I'm very pleased to welcome you to this event and keynote speech, The EU as a Constitutional Democracy, Courts, Values and Political Conflicts, where we're hosting Tamara Ćapeta from the Court of Justice of the European Union. And I'm very happy also to welcome you on behalf of both the Jacques Delors Centre and the Centre of Fundamental Rights of the Hertie School. My job, I've got the easiest job today. All I've got to do is introduce our keynote speaker. Many of you, certainly those of you who are familiar with European law, will very much know already a lot about the work of Tamara Ćapeta. There is a kind of tendency in European law for really central cases, for important cases, kind of the sexy cases in EU law, to cluster around one particular advocate general. So we had Francis Jacobs, we had Miguel Maduro, Eleanor Sharpston, and today we have Tamara Ćapeta. So many of the kind of most interesting cases of EU law, and also really many of the most interesting ideas about the development of European law are being developed in her opinions. So many of you will know many of the opinions in which she's been very active. Tamara is the Jean Monnet Professor of European Law at the University of Zagreb, where she completed her PhD in law in 2001, before which she studied at the College of Europe in Bruges. In 2021, she was nominated by the government of Croatia to act as Advocate General at the Court of Justice, taking up her position in October of that year. And as actually we discussed a little bit earlier on, Tamara was even the one who translated the term Advocate General into Croatian. So it's quite an irony that sort of this position that she studied and that she coined in the Croatian language, she now represents Croatia in that post at the court. Since taking office in 2021, she's been the author of many of the court's most consequential opinions, from the question of whether and under what circumstances EU values are justiciable, to the meaning of racial discrimination in social housing, to the responsibility of Frontex in migration management, and many more issues. And more broadly, many of her opinions have focused on the notion of the EU as a constitutional democracy and what this implies for its political and its legal order, which she will speak about today. Just to give a few words on our kind of order of business today, I will invite Tamara Ćapeta to make her keynote address, and then I'll invite two speakers I'm also very pleased to introduce and have with us. Anna Bobic, who's a senior researcher at the Jacques Delors Centre and also for several years worked in the cabinet of Tamara Ćapeta at the Court of Justice, and Violeta Mourinho-Lax, who many of you will also know, a professor of international law and the director of the Centre of Fundamental Rights. So we'll have a small roundtable after the opening speech, and then we'll have a question and answer session. So before further ado, please join me in welcoming Tamara Ćapeta.
Thank you, Mark. Thank you for these very, very nice words, which I'm not certain that I deserve yet. Thank you, both of you, Mark and Violeta, for inviting me here in a beautiful Berlin that is very different than 2 weeks ago when I was here, and I almost broke my leg. So it's incredible how it can change so quickly. So I'm really, really thrilled to be here, and thank you for all of you who walked or biked here today. And not only that, you biked here, you didn't bike somewhere in nature, in some nice cafe. So thank you very much for wanting to be here, and I am really, really honored that you came to hear what I have to say. Okay, so with not much ado, I will try to start. And I will tell you immediately that Mark and Anna asked me to explain to you my own vision of EU constitution. In short, they kind of asked me which kind of constitutional narrative am I proposing to the court through my opinions. It is like, no pressure, Tamara. Just your own theory of everything. So I'm going to do this in two parts. In the first part, I'm going to talk on a more abstract level about a vision I have of EU constitution. And then in the second part, I will go into concrete problems when this abstract vision has to be applied by the court. Okay, so starting with the abstract vision, one problem in providing you with my holistic vision of my narrative is that, unlike in academia, in the court we actually think through cases as they come, and we are trying to find the best answers to the questions that those cases raise. No, so we do not necessarily start from some big picture, which gives us then the answers. We are rather doing the reverse, piece by piece, case by case. Bigger picture might emerge. So I will try to explain to you that larger picture that is possibly emerging for me. And is being painted on my canvas. However, I will actually need your help later on, and I'm counting on your help to add appropriate colors on my canvas on different parts of that picture. In order to be able to do that, so that we have enough time for discussion, I will try to keep the promise and stay under 30 minutes, and then we can discuss later. Now, to my mind, a narrative explaining the European Union as a constitutional democracy is not new. It is present for a longer time, and it has even survived the failure of the project of the introduction of the formal constitution in 2005. However, today it is facing some new challenges. It was always facing some challenges. Today it is facing some challenges of a new kind, maybe, which is why maybe this narrative must be now narrated differently and maybe even more clearly. Since recently that constitutional narrative does turned on EU values. It has turned into something that some scholars named already value constitutionalism. And this raises questions like, for example, why is there this turn towards values? What consequences are there from such a turn to values for the polity that is being built within the European Union? What are the drawbacks or dangers of turning to values, or whether there are some good sides, and what are they? But we can also ask, is this indeed a new narrative? Or merely it is a logical evolution of the past developments of the EU legal order, which were possibly speeded up a little bit by external events. And I tend to lean to such explanation. In my understanding, the European Union became a polity that is organized by a constitution ever since Van Henten Law's judgment. And I've heard that you all heard about it already. And that was some 70 years ago. So you don't remember it, but you have heard about it. So why was this a constitutionalizing moment from the lawyer's perspective? First, what the court addressed there as a new legal order, even though based on the treaties, became autonomous, that is free from international legal order in which it started its existence, and free from national orders of its member states. And then you can also ask, free in what sense? What does that mean? I would say that it became free in the sense that the meaning and the effects of the rules of this new legal order now are since that moment interpreted from within, from that legal order itself. They don't depend on others. However, that in itself would of course not be sufficient for the birth of a constitution. So second, and equally important thing that happened is that this court's proposal to construe treaty as an autonomous and self-explaining instrument was in time accepted by the constituent parts of this constitutional order, its member states and its citizens. The fact that some features of the new legal order were contested, and they're still contested, does not diminish the constitutional nature of the EU order. Rather, those contestations coming either from politics or from the national constitutional courts, confirm, on the one hand, the existence of the EU constitution. For example, dialogue between constitutional court is not possible if each court is not defending its constitution, which kind of makes it clear that European Court of Justice and the treaties behind it are also this constitution in the constitutional dialogue. On the other hand, these contestations are part of the EU constitutionalism itself, a feature that is peculiar for the novel nature of a composite constitution, which was termed by some constitutional pluralism, and some people like Anna here wrote a lot about it. And I'm happy that I had her with me, so I could learn from her directly, not only from her books. Now, at the same moment when the EU got its constitution, it also got itself a constitutional court. So what makes the Court of Justice constitutional court, in my view, is its power that is embedded in the constitution itself to have a final word in the interpretation of the meaning and the effects of the EU constitutional norms. And that means that the court has an important role in the development of the EU constitutional narrative. However, and I will come back to this, it does not have a monopoly over this EU constitutional story. The original narrative of EU constitution was not surprisingly based on market freedoms. And that has often attracted criticism that the court was pushing forward some neoliberal project. Such criticism missed, in my view, certain developments, such as human rights and social dimension that was being built up on top of the EU's economic constitution, either by the court or by EU legislation. But however, explaining today EU constitutionalism through the prism of values and building EU's constitutional identity on Article 2, rather than on internal market chapter of the treaties, might be, on the one hand, an effort to prove the neoliberal vision wrong. In your case law, it is even very evident that, internal market or citizenship that was built upon it, at least in its free movement aspect, are often used to advance human rights. And I'm talking about the cases like Pančarevo or Trojan Voivoda Mazowiecki, which enhanced through mutual recognition the equality of same-sex couples, for example. And then on the other hand, maybe the turn to values signifies a change in the nature of EU constitutionalism, responding actually to the criticisms of its neoliberal nature. Another different type of criticism of the existence of the European Union as a constitutional order and the court as its constitutional court comes from the perspectives accentuating the lack of democracy at the EU level. Why? Because there is no demos, or as argued by some, there is not even a possibility of having a demos at the European level. So courts' reliance on values, including the value of democracy, can be also seen as an invitation to reimagine the European Union in democratic terms, given that certainly democracy was the choice of the member states and it was included expressly in the text of the treaties ever since the Maastricht Amendment. Now, this lack of demos at the EU level brings about very often the insistence of saying that European Union is an international organization and trying to persuade everyone that it is not a state, which obviously it isn't. However, even if some polity at the EU level is recognized, the usual criticism is that there is a democratic deficit at the EU level. So therefore, even if there is a constitution, it is not a constitutional democracy. Now, without any attempts to discuss here to which degree such deficit exists or doesn't exist, I would like to propose that such criticism is often the result of a difficulty to imagine a different polity than those that exist within nation states. So the conclusion about the democratic deficit comes because the EU institutions and processes simply do not correspond to those with which we are familiar. And in that regard, there are attempts to find novel explanations which can describe and defend EU as a constitutional democracy without demos. And I would mention Calypso Nicolaides and her concept of demoicracy, or recent attempts of Armin von Bogdan, and I see Sylvia there, and Dimitri somewhere, yeah, to propose the concept of European society as justifying and legitimizing EU constitutionalism based on values. And I should probably also mention among these attempts the recent speeches of Koen Lenaerts, the president of my court, who was describing the European Union as a democratic union of democracies. Now, the European Union's democracy is indeed, in my understanding, dependent on both its member states and their peoples and the EU citizens. It is a sort of a federal constitutional order organized by a constitution on federal level and constitutions at the level of member states. And Article 2 becomes important to organize that composite polity. The values it expresses, Article 2 expresses, and without the need here to enter into discussion, why are there two sentences in Article 2, and what is the mutual relations of the values in first sentence to the values in the second sentence or similar, I would just like to suggest here that Article 2 is very clearly paints a picture of liberal democracy, or what I have called, in my opinion, Commission v. Hungary, a democracy which respects human rights. And this expresses an idea that public power on either member state or European Union level is bound by law, and that the decision-making is constrained by the respect of human rights. And importantly, in my reading of Article 2, it expresses also that to enable functioning of this composite polity, which is endowed by very broad regulatory powers, as is European Union, it is necessary that both its constituent parts and the EU itself recognize the same basic values expressed in this model of liberal democracy. And for that reason, we have Article 49, which conditions accession to the European Union with the respect of values in Article 2. The Union simply cannot function if the member states are not themselves liberal democracies. But the Union itself also has to be committed to those values. At the same time, it is not the Union that imposes on its member states liberal democracy. It was, and it is, I would say, a choice of the member states to build a polity on those terms. So, in my view, Article 2 is an expression of shared constitutional values, and that is despite the differences of institutional arrangements in which national constitutions arrange those same values. They may differ, but the basics don't. This is not necessarily undisputed. There was a recent article by Signe Larsen in Icon that maybe challenges a little bit this, but I read it and I would agree with lots of it, especially her treatment of federalism. However, there is still, in my view, a shared constitutional core that exists and is expressed in Article 2. Now, even though the narrative of values is most often today mentioned in relation to these rogue member states, okay, Hungary in Commission with Hungary, or Poland in this series of cases that related to independence of judiciary in that state, it is, in my view, equally important to require the same respect of these liberal values from the Union's institutions and bodies. And that is what my recent opinions try to express. And maybe with an even more strong accent on the need to submit the European Union to the requirements of a democratic constitution. Commission v. Hungary obviously was about a member state, and so was the Danish housing case. However, in cases such as KSKD, or Front Polisario, or Frontex, or recent 2 weeks ago, last week, I don't remember anymore, European Parliament versus Commission, which also had Hungary in the center, but it was actually about the powers of the Commission, I tried to express that EU institutions and bodies must equally abide by law, respect human rights, and be submitted to judicial control of their actions. And I'm sure that Violetta will have to say something about that in relation to the asylum situation. So in short, I'm of the view that the EU treaties paint the picture of the European Union as liberal democracy, composed of the states that are themselves also liberal democracies. And if you want me to finish my first part of the speech, I could say that EU may be described as a federal liberal democratic order based on shared values expressed in EU constitution. And this now leads me to go to my second part, which is more difficult, actually. Second part, in which I can start by saying that saying all this, defining the union this way, is easily acceptable on this abstract level. It becomes much more difficult when one moves step down and thinks about concrete application of values, and importantly, from my perspective, a concrete application of this value by the court in real-life situations. It gets, of course, even more complicated where composite parts of the EU legal order, of the EU constitution, change and abandon some features of liberal constitutionalism. So this turn to values before the court, actually, and by the court, meets today a different type of criticism, that imposing values on member states and their citizens is in itself actually undemocratic, that it prevents actually constituent constitutions to choose and change their values. This is how I understand some of academic criticism, which I did take seriously when I was asked to advise the court how to respond to the Commission's claim that Hungary breached Article 2. And what I would like now to do in the rest of my time is, on the basis of that case, to discuss with you problems that deciding cases on the basis of values entail. And I assume that all of you know that in Commission v. Hungary, the court is faced with the question whether, on top of the infringement of several EU acts, so some legislation, which is all in the area of free movement of services of different type, and then several rights which are guaranteed by the EU Charter of Fundamental Rights, the court is then asked to separately also declare that Hungary infringed Article 2, so this article that enshrines EU values. And now, before I continue, I wish to bring to your attention two introductory remarks. First one is that this is an infringement action. So Commission v. Hungary only requires the court to assess whether Hungarian legislation, including, importantly to my view, the way in which that state tries to justify it, is contrary to Article 2. It does not, it requires just some type of a negative assessment. The court should only say whether that is acceptable and should not provide a positive answer in the sense of saying what is acceptable. And then second, once the case is brought to the court has to provide a decision. The court cannot say, oh, it's too early, we don't know yet what to do with values, so wait a little bit, okay? We have a case now, and we have to give some response now. Now, going back to Commission v. Hungary, very short intro into what this case is about, even though you all probably know it. Hungary introduced an amending law which brought changes in a number of legislative acts, including those relating to provision of services. And as I said, Commission only brought it on the basis of services. There were other legislation that was also affected, potentially. Those amendments prohibited access to what I called LGBTI content, with the justification that this is done for the protection of physical, mental, and moral development of minors. And the disagreement on the level of values was obvious during the procedure in which the Commission, the Parliament, and 16 intervening member states did not consider, unlike Hungary, that exposing minors to any kind of information about LGBTI lives can in itself be harmful to their development. Now, the topic of the case is sensitive because it brings a lot of different sub-issues in, but they were not treated by Hungary as sub-issues. LGBTIQ plus was treated as a group of society. However, they of course have the issues of gender identity. Societies are very much not yet in agreement about can you change gender, can you choose gender, and so on. So part of the academia did warn that this is not a good case, that this is a sensitive case for testing the question of justiciability of values. And even if that might be so, the case is there. So as I told you, once the case is there, the court has to provide an answer. Now, in Commission v. Hungary, the court has three options. One option is either the court will find that values are not legal concepts, so the court cannot use them in adjudication, and say we are not accepting the third plea brought by the Commission. Or the court can find that values are usable by courts, so justiciable, but find that it is not necessary to find infringement of Article 2 in the case at hand. And finally, what the court can do is find that the values are justiciable, assess whether they were infringed in that particular, and assess whether they were really infringed in that particular case by Hungary. But for this latter, the court needs to have some criteria according to which it will decide whether values were or were not breached. So let me go to the first option. Values are not law. Given the preceding developments in the case law, in which the court has already relied heavily on values, it could seem strange that the court would now discard values as legal concept, so something usable by courts. And I have no time to go into those cases. I will just mention some, like from Opinion 213 on the accession of the Union to the Convention of Human Rights, through Associação Sindical dos Juízes Portugueses, or the case República, or finally conditionality judgments. All these cases used values. So first option I don't think is real. The second option, the court could find the values to be used or usable as a yardstick for the assessment of national, or for that matter also EU legislation once, but also decide that after finding the breach of EU legislation and then of several charter rights, and important charter rights like equality, like right to speech, like human dignity, that after all this it is unnecessary, to assess the breach of values as well. Okay, so in Commission with Hungary, that could indeed be a solution, because if the court finds the first two alleged infringements, Hungary simply would be obliged to withdraw or amend its legislation. However, it is very difficult to imagine any serious type of breach, so the type of breach in which would ever invite the court to decide about Article 2, that would not involve at the same time a breach of some rule of EU law, and for that reason involve the Charter, and then involve also breach of some Charter rights. So choosing this option in Commission v. Hungary would not in the end be very different from saying values are not justiciable, or not necessarily not justiciable, but they are not useful. We just don't need them in infringement proceedings ever as any additional yardstick, because in most cases this is simply not necessary. And so we come to the third solution, which would be that the court recognizes values as a possible yardstick and go there. Okay. Now, the question I ask myself is, what would be the added value of this? Is there any added value? To my mind, one possible added value is diagnostic. So it is to point out what is the cause of all other breaches. So the breach of a charter right is not just a breach of a charter right, it is the breach of the charter right because there is a problem with accepting the model of liberal democracy that Article 2 enshrines. However, it is still very difficult to say what are the legal from the difference from political effects of such finding in infringement procedure. This is not entirely clear. So let me now move to the more complex problem. And this is the one that in essence asks how to enable in the Union unity in diversity, which is our slogan, united in diversity, no? Values in Article 2 are vague notions, and their meaning is open for debate. In the Union that is composed of its own, but also of member states' constitutions, different visions of the more concrete meaning of these values have equal standing, at least until one of them prevails. If a uniform interpretation is necessary at all, and that's also debatable, it is ideally a result of a political process and not of judicial interpretation. And there are thus two problems that I have noticed. One is the legitimacy of the court to say what values mean, and the second is necessity not to close the dialogue or to leave some room for diversity. And for this reason, it is clear that the finding of a breach of values by the court should happen only exceptionally, only when the behavior of or legislation of a member state is entirely outside of the model of liberal democracy in Article 2. And it is there where I borrowed the idea of red lines from Armin again, von Bogdan and Dimitri, speaker here. There are simply certain situations in which the crossing of red lines would be clear. Imagine a state abandoning elections. Not so unimaginable today, no? Just saying, okay, elections are closed, so that's it, we are not having elections anymore. Or deciding that courts cannot ever review any government election. This would be very clear breaches of a concept in Article 2. However, the situations are not always that clear. And therefore, admitting values as yardstick for finding infringement requires determining some criteria. And in that respect, the discussions in written part of the proceedings in Commission with Hungary and during the hearing revolved around the ideas of serious and systemic breaches. And this was most likely inspired by the wording of Article 7, which introduces political process for dealing with breaches of values. However, to my mind, that was not a satisfactory solution, because even a systemic breach, and in the case at issue, that was a breach really that spread across different areas of domestic legal system, even such systemic breaches do not have to be the result of non-respect of values. They can be a result of different balancing between two rights. They can be the result, of different understanding of the content of a right. You all probably listened about a Bega case in which the court a long time ago said, yes, we can have different concepts of human dignity, no? So that wouldn't stand for saying there is a breach of Article 2, just because it would maybe spread among more areas of social life, no? So the solution that I proposed is that we have a negation of values as a criterion. And that would be a situation in which a state does not understand an element of the EU model of liberal democracy, such as equality of an entire social group, as a value that should be granted constitutional protection. Such negation would then be, of course, of serious nature, especially of serious nature for the EU composite constitutional order. Because, as I said before, that order can only function if everybody respects the basics of this liberal constitutionalism. And then it would be serious. So serious becomes as an important notion in this story, but we cannot define for serious what is actually the breach of values. And I am aware that negation of values is a very open concept itself and will need further elaboration. For example, has Denmark negated values when distinguished their inhabitants on the basis of an ethnic criterion which led some to disadvantaged position, the question which did not, but could have, arisen in the Danish housing case, no? I have my opinion about it, but this is questionable. Is that negation of values? Is it not? And why, yes or not? However, as the president of my court, and I'm mentioning him second time today, but he often explains that the case law develops incrementally, step by step. So it is not necessary to resolve all the issues at once. So however the court decides this case, and the case is still pending before the court, only my opinion was out, the discussion about the legal value of values is now open, it's on the market, and will be present in scholarly writings in the years to come. And I'm really looking forward to reading some of your contributions here about that topic. And in the meantime, I would love to hear your opinion in the remaining time we have here. Thank you very much. And I was under 30.
Perfect. Okay, thank you very much, Tamara, for that wonderful opener. We're now going to have a small round table. Indeed, as Tamara said at the beginning, we asked for her whole philosophy of European law. I'm not going to ask that of Violetta and Anna, but what would be great is to get some of your reactions to this topic of the EU as a constitutional democracy, how the EU relates to values. Would you like to start, Violetta?
I mean, I think Anna then will have the more difficult task of saying things that we haven't yet said, but right, okay. I just wanted to thank Mark and the Jacques Delors Center for the collaboration and Tamara Ćapeta for being here with us today and for this privilege of sharing the podium with you and be able to engage in a conversation on your vision on the EU's constitution. And the thing is, when preparing my notes, I mean, I was thinking precisely of the Danish ghetto laws case and the Hungary LGBTI content case. So it's a very happy coincidence that we're going to be discussing these two cases. I think actually the one line of your work that stands out, as it's been exemplified here today, is your work on EU values and the protection of fundamental rights. And I wanted to highlight these two landmark cases. One decided already in December last year, the other one still pending. So your opinion on each of these cases have advanced significantly our thinking of EU law as a constitutional democratic system, and very much as one that promotes a rights-enhancing reading of key constitutional norms. And so in the Danish ghetto laws case, for instance, where it's at stake, as you have briefly pointed out, is the determination that the recent national reform of the national housing system in Denmark is a scheme that is based on racial discrimination on grounds of ethnic origin, insofar as it targets areas designated as transformation areas, formerly known as hard ghetto areas explicitly in the previous legislation before the reform. And these are areas characterized by a number of socioeconomic markers like poverty, unemployment, criminality, and crucially, and this is the point of contention in the case with which you take issue, a concentration of immigrants and their descendants from non-Western countries above 50%. So what you do here is basically criticize the Danish legislator and the plan of these areas being in need of gentrification through the reduction of migrant non-white presence in these areas, including through the termination of leases and forcible eviction of inhabitants of these areas. And your opinion on the case has been very powerful in clearly establishing that such a measure should be considered a form of direct discrimination unapologetically, that it is incompatible, therefore, with the principle of equality as enshrined in the Charter, the Race Equality Directive, and Article 2 of the EU Treaty. So you do mention Article 2 in this case as well. And this is, by and large, been followed by the Court of Justice in its judgment, except for the fact that the court appears to be a bit less clear as for whether the measure should be considered categorically as prohibited, as being an act of direct discrimination on grounds of ethnicity, or whether it could be considered merely indirect discrimination. And this is quite contentious, right? Because the difference is consequential. While direct discrimination can never be justified under EU law, indirect discrimination can be justified if it pursues a legitimate goal and meets the requirements of proportionality. And the court seems precisely to hint at that possibility, especially when non-citizens are concerned. And indeed, so what the court says, paragraphs 149 to 51 of the judgment, for those that might have the judgment to hand, while integration policy objectives cannot justify the unequal treatment of Danish nationals, who by definition would also be EU citizens, it seems to accept that such an objective can be accepted if the unequal treatment in question affects non-citizens. Others have already mentioned that this is very problematic, so I'm just going to add my voice to this. It appears to legitimize a two-track system of protection against racial discrimination that is difficult to square with the very purpose of the Race Equality Directive, as it runs counter the very objective of eliminating this form of discrimination. And this dual-track system appears to hinge solely on grounds of nationality, which for the court and many in academia does not seem to be a proxy for race or ethnic discrimination. Others would hold a different view, so that discrimination on grounds of nationality, which EU law appears to permit, in fact, should be read as another way of entailing discrimination on grounds of ethnic origin or race. And I would be very curious to know what your opinion on this is, if you can, because I don't know if you are allowed to criticize your own court, but so if you can, your position on this would be very illuminating, because it would also allow us to understand whether, as part of your vision, the EU can constitutionally develop a two-track system of what amounts or not to race discrimination, and whether this is compatible or not with your vision of Article 2. And this question allows me to come to the second judgment that you have extensively discussed as well, so the one on the LGBTI content case, and the unprecedented plea by the European Commission to declare the justiciability of EU values as a self-standing ground rather than autonomous. It would be great if you could address the difference between the two and whether you think that this would work as an autonomous ground as well, to find that there has been an infringement of EU law on the part of Hungary. And you have been very clear in your opinion that Hungary's decision to ban LGBTI content from the public domain cannot be justified under any means whatsoever. It constitutes a misplaced value judgment based on a prejudice that heterosexual cisgender life is not deserving of equal protection because it doesn't have equal value or status as in the mind of the Hungarian legislator. And this is in stark discrepancy with the values of human dignity, equality, and respect for human rights, as you mentioned in your opinion. So the legislation, in fact, represents an active contribution, and I'm reading your own words, to the stigmatization of this minority group that enhances pre-existing social prejudices and stereotypes that undermine the very essence of the value of equality, creating a climate of hostility. So, to substantiate your argumentation, you have recourse to Article 2, asserting, as you have done today, its justiciability on a number of grounds that we can also further discuss in the Q&A, including the essential function that founding values play in enabling the functioning of the EU legal order as a whole. So for you, it's sort of like the hinge on which it all revolves and that articulates your vision of a good society. Good society, again, in quotation marks, as taken from your own words in your opinion. And in your account, I understand Article 2 demarcates these red lines that von Bogdandi and Dimitri here have characterized in their own work, and you take, in your opinion, that member states cannot trespass when acting within the confines of the EU legal framework, including when concretizing EU values in their own domestic legal systems. I'm coming to slowly to an end. But so what is less clear is the test that you have explained here today, according to which these red lines can be said to have been crossed. You propose this concept of negation of values. This is for you the key criterion to decide on a case-by-case cases whether a member state has infringed its Article 2 EU treaty obligations, but have not fully established how exactly the negation of values can be identified and differentiated from ordinary violations of fundamental rights, including if these are grave, systematic, systemic, serious, and other adjectives that we could use to describe otherwise intense breaches of fundamental rights. You also say at some point in your opinion that you don't think that quantitative or qualitative matters would on their own serve as grounds for determining that there has been a breach of Article 2. And so I understand why this is left open and for the court to be determined. But I would also understand the criticism that we do require some legal certainty, that we do require member states to be able to predict a priori what are the types of behavior that would be considered outside the legitimate constitutional dialogue, and therefore as a trespass into this territory whereby you would find a negation of values. So you've used the example of the cancellation of elections as such an example. I would wonder, coming back to another one that you have hinted at, would the negation of equality as seen in the Danish ghetto laws be also constitutive of such a negation of values, in your view, insofar as those laws appear to indicate that persons of immigrant, non-Western descent are an unwanted part of society who do not deserve to be treated equally, paraphrasing your own words again in your opinion in the case. Should this then be considered a breach of Article 2? And if this is the case, pushing the argument a bit further, does the fact that the new pact reforms on EU migration and asylum law, which seem to be based on a similar perception, should we then consider that the package of reforms runs counter to the founding values of the Union? Can the EU legislator ever be found to be in breach of Article 2 of the EU, or is this only a mechanism to controlling compliance on the part of the member states? To my mind, if we are serious about the principle of equality and human dignity as the Grundnorm of post-World War European constitutionalism, in the words of Advocate General Cocotte, that you cite again in your opinion yourself, which the EU and the member states must respect and promote in all of their activities in relation to both the internal and the external dimension of their policies, then the manner in which EU migration and asylum policy is currently developing should be a source of concern, incompatible with the good society painted by your vision of Article 2 of the EU Treaty. Or is the fact that third country nationals do not belong in the EU demos or demoi or the European society notion be such as to justify a departure from that vision? Is the vision one that is reserved for those described as belonging into the European society, the demos, the demoi of the EU member states, to the exclusion of non-EU citizens? Is that sustainable? Is that in line with the EU described as a democratic system of liberal democracies that respects human rights, considering that one core feature of human rights is universality, another one is inalienability? Is this two-track system really compatible with your vision, Article 2, and EU founding values? And If your answer is yes, what is the consequence of this bifurcation? If your answer is no, what is the consequence for the entire area of freedom, security, and justice, which is premised upon this very distinction? I'll leave it there. Thank you very much in anticipation of your answers. Thanks a lot.
Okay, thank you very much, Violetta. I'm tempted to pass the question to Tamara, but that would take us too long, I suspect. So I will hand over to Anna first before we go into our discussion.
Thank you. I'm going to let us all breathe from these extremely difficult questions, which I wonder how you're going to answer. I think I'm going to kind of divide my remarks in two parts, which reflect, I think, the two roles that I had working for you. So I was a legal clerk in Tamara's cabinet for 3 years, and I saw my job as being two things. One was to be your biggest fan, to support your work, do everything I can to make your opinions a success, right? So that was... So that was one part of my job. And the second part of my job, of course it's related, is to be your biggest critic, right? So to make sure that the biggest criticism, the harshest one, you hear before the opinions are out there. And so I'm going to do these two things. I'm going to be a big fan of yours for a few minutes and then a biggest critic of yours for another few minutes. First of all, thank you for indulging our question on what is an EU constitution a la Tamara Ćapeta. I know that you yourself maybe didn't see it in this way. I certainly saw it in that way when all these big cases started coming. And I think that our very long meetings always reflected the big question that you have to think about how this will affect other cases. And how it will reflect bigger constitutional issues. So in a way, your cases really allowed you to develop this big vision, whether you'll want to accept it or not. And so thank you for telling us about it. I think that the cases that you've had, and I'm going to mention a bit more of them than you did, they tell us something fundamental about the EU. What the EU is, right? So a large part of your opinions deal with accountability of member states and EU institutions based on fundamental rights. So last week, you told the court that they should annul the Commission's decision for unblocking funds for Hungary because the Commission has breached its obligations, right? The Commission has misused its discretion. You have also told the court that Frontex should be liable for fundamental rights breaches and that EU missions in external action, although the court's jurisdiction is kind of excluded by the treaties in external action, still fundamental rights should apply there. So there's a big part of your work that really kind of forces the court and the institutions and the member states to think twice about their actions because there is accountability really formed in fundamental rights. And the second area that I think your opinions really build is a bit to the belonging topic of Violetta's comments, is what sort of community the EU is. So thank you for describing in a lot of detail the Danish ghetto case. So here, your opinion really tells us what sort of society we should not be, right? We should not be racist, we should not be excluding people who don't have a Western background, whatever that means. But there are other cases. In your recent opinion in Safi, you told us that citizenship rights shouldn't just be tied to free movement. They shouldn't be just market rights. We should, as EU citizens, also have a right not to move and then enjoy EU rights regardless. In Chief Appeals Officer, a year ago or so, you also told us that dependence and the right of residence should also not be just a financial economic category, but rather something also connected to emotional dependence and so on. So again, a non-market vision of belonging and operating of citizens in the EU. And I think what really makes these cases also interesting is that the court afterwards sometimes seems short-sighted, right? Of course, Violetta exposed really the great kind of, I'm going to call it the great sin of the Court of Justice in the Danish ghetto decision, allowing for possible discrimination of non-EU citizens. But the court somehow seems stuck with the facts of the case. Of course, your response will be that the court is deciding a case, that's true, but there are other cases like Commission versus Malta, where the court is happy to really decide on fundamental issues. So it seems to me that the court is not always following you. So maybe something you can reflect on is whether you see that as a success. I think that if I were an advocate general, I would be proud not to be followed. So that much for praise. Now for some criticism. I think that there are kind of 2 points or 2 tendencies that stand out in your vision that I find perhaps maybe problematic, maybe simply something that we need to discuss a bit more explicitly. The first one is a very important role for the court. So I already mentioned this case and KD judgment. This is a case in which, Tamara, you proposed, and the court sort of accepted, but a bit in different phrasing, that although the treaties exclude the jurisdiction of the court in external matters, the court should still always be able to adjudicate on fundamental right issues, so that external action or foreign policy of the EU should never have such discretion as to breach fundamental rights. Now, this is one way in which, of course, the court is significantly strengthened. Of course, this is a great victory for fundamental rights, but it's also a great victory for the court in the institutional balance to other EU institutions. This is also the case in Commission versus Hungary. If the court accepts your proposal that values are indeed justiciable, this would, of course, significantly expand the jurisdiction of the court. This, of course, aligns with what you said, that you see the court of justice as a constitutional court of the EU. So that is one kind of consequence, I think, that we can see from your opinions. And then the second one, of course, it's slightly connected, is that among the institutions, political and legal institutions in the EU, the court has kind of become the arena of a kind of a Habermasian public sphere. This is where, according to your vision, if I'm not wrong, where mediation happens, right? Where social conflict happens and is resolved. Now, you said earlier that not deciding a case is not possible. That's true, of course. But of course, it's also possible to say that some issues cannot be decided by the court, but should maybe be decided by political institutions or other ways of political expression or democratic expression. So, for example, to say what is a good society, we of course might agree with your vision in the opinion, but we might also ask whether it is really for the court to say something about what is a good society. So, similarly to what Violetta was asking about your test, about the negation of values, whether the court is really able to determine what values are, how to adjudicate conflicts between them, and really the problem of red lines, right? So it's always a case-by-case decision, so really this red lines test seems very problematic. And you said yourself that red lines is something very, very exceptional. And then it makes me wonder whether really such exceptional problems should be decided by the court, who resolves more or less standard cases, although important, but not such that really question what the EU is. So it also seems to me that these problems come about, of course, and these outcomes come about because the conflicts between the member states and the EU are really increasing, and the court seems to be the only institution left with the power to say something. And I wonder whether this is a good enough reason for the court to then do this. Yeah, so it seems to me that we, in this vision, kind of see that the EU is sorely missing a public sphere of a different kind that is not the court. Thank you.
Okay, thank you very much, Anna. So maybe just very quickly, we'll give you the chance, Tamara, to respond. Maybe to a sort of a couple of themes. So one was this theme of sort of bifurcation of human rights, potentially, between EU citizens and non-citizens, and how that relates to values. Because values could be a way of solving that problem, but of course values is often, or especially when it's tied to an idea of society, it can be a notion of this is our values, and these are the values of others. So it's not always something helpful in that context. And then finally, sort of basically EU values versus the legislature and the political realm. So I interpreted Violetta as, wanting the court to go much further in that direction, and Anna is being much more reluctant about judicialization of political processes. So do you have any thoughts on these points?
Yeah. Oh, thank you. This is very difficult, all these questions, and I think that I did say something about some of them. And I mean, first on, yeah, what Violeta mentioned, and the passage in the judgment in which citizens are maybe put in a different situation in relation to the discrimination on ethnic grounds. I'm not certain whether the court really wanted to say this in the judgment. I'm still not certain what the court wanted to do with that sentence. You know, court is the collegiate court, so sometimes sentences stay not completely finished. In any case, as you say, human rights are universal rights. So you cannot say we are going to treat on the basis of human rights people who are not citizens differently. There are, of course, situations in which we treat citizens differently. I mean, only citizens can vote, for example. So we already do have a lot of discriminations that we do allow in society. However, obviously, human rights violations cannot be one of them, in my view. So I'm not completely certain what the court wanted to do there and where did they want to go. Maybe they just wanted to strengthen through this the concept of citizenship without really seeing that this is causing another type of problem. But yes, I would absolutely agree with you that this cannot be, that human rights are universal. We do have a problem in a way, maybe in the charter. This is the topic for when I return to academia, you know, that the charter actually has a lot of fundamental rights, and not all of these fundamental rights are actually universal rights. So we grouped a lot of things there, but some of those rights are certainly human rights, and if we want to stick to this notion that is being endangered now, there is attacks on the Strasbourg court now recently, then we have to stick to the human rights as universal and inalienable, as you said. And now, you also asked me about, of course, asylum package and all the asylum problems, and this is probably the most difficult question when it comes to values, because, and this is also visible in the Danish case, you know, I mean, in the Danish case, I mean, you cannot neglect that this is a real problem in society. They do have neighborhoods which are maybe problematic. They want to do something with it. It happens in Sweden as well. It is not that we have to be, we don't recognize what's happening in the real life just because we are now suddenly in the world of law, no? So there should be some possibilities how to deal with these kind of problems, and obviously the Court of Justice cannot decide for Denmark how to deal with such problems. However, it was so obvious that in the Danish case they could do the same thing without having the group of non-Western citizens and maybe reach the similar results, which then can be maybe justified, which they did try to justify it as trying to do good for those people whom they were discriminating against, no? If they were discriminating, I don't know yet. This is for the National Court now to find out. So we have to see whether that was discrimination. But the big topic in Danish case and in some other cases was the question of stigmatization. And this is the question also in the Danish, in Commission v. Hungary case, which is somehow a phenomenon that is not situated in the debates on non-discrimination law. Where do we go with stigmatization? Is that direct discrimination? Is that indirect discrimination? Is that discrimination at all? You know? And I have the feeling that many of these cases actually reflect what I would call stigmatization. There are some people who were working a lot about it. Iola Solanke, for example, published a book on it. And this is what kind of was very important for me also in those cases, that this is what could be recognized, that of course stigmatization exists in society, but the problem exists when it is the government that actually causes more societal stigmatization instead of doing contrary, whether it is the LGBTI group, whether it is different ethnic groups and so on. And now you ask me whether EU is subject to Article 2. Yes, of course, I mean, obviously Article 2 and all rights are primarily, and the treaties and charter, the entire charter, certainly bind the European Union. What we are not completely certain whether it always binds the member states, no, because the charter itself says that it binds the member states only when they implement EU law, but it always binds European Union. So, yes, European Union is bound by this. What would that mean for the asylum package? I'm not going to answer because this might come to the court and I didn't go into details as you did yet in this. What I can say as not someone from the court is that yes, we do have a huge problem in all societies today with migrations, and we cannot say that this is not a problem. And it's going to become a bigger problem because we are going to have climate migrants, and we are going to have different types of migrants, and many of them migrate into European Union. And obviously, if too many of them migrate into European Union, there might be a problem. So there is obvious reason why political institutions want somehow to resolve this. What I can say from the point of view of the court is that, yes, we have to think about it. The best way to solve it would be to solve the situations in those countries, and then they wouldn't have the reason to migrate. But this was actually the policy of the European Union for a long time in Africa, for example, and so on. Didn't necessarily work. However, whatever is going to be the response, and I can understand that there are sensitivities and that there are real-life sensitivities about which the political institutions and political process has to think about, whatever they think about, what we as the court have to tell them is you have to think about it by having in mind fundamental rights and values, that those shouldn't be violated, and that if it is necessary sometimes to maybe infringe some of charter rights, then you have to have a good justification and how to balance it. Now, the point is that, fundamental rights are very often seen, human rights are seen as just individual thing, but they're not, because most of the individual rights can be infringed if this is for some collective good cause. So if you can find a collective good cause that is justifying infringement of particular individual rights, this can be accepted, but it has to be thought of in these terms. That's more or less, but if I had the answer for you, more than that, then I would actually run for the European Commission or some other position, not the court. What else did we have? Do you want me to answer everything immediately?
Maybe I bring in the audience, if that's okay.
Yes.
So you've all been waiting patiently. Yeah. So please, if you could put up your hand if you have a question. Maybe you could also very briefly introduce yourself when you ask your question. That would be wonderful. So let's start on this side of the room. Yes, please.
Hi, my name is Ricarda Niehaus. I work at a think tank here in Berlin, the German Council on Foreign Relations. And Tamara, I wanted to connect two points from your speech earlier. One is that you alluded to it just a minute ago, that the principles of constitutional democracy also apply to the European institutions themselves. And then at the end, quoting your court president about the fact that case law will advance incrementally. And if I could tempt you to maybe answer this as a political question, and maybe make take a guess or see where you think this would go. Where do you see the next steps incrementally of cases being brought against EU institutions, similar to the one that is still pending at the court now in Parliament versus the Commission, but maybe also you can see that we are going in similar directions in the years down the line. Thank you.
Maybe we take another question, so please. Yeah. Here.
Yes.
Please. Thank you. Hi, my name is Joan Sabira. I'm a prospective student here at the Hertie School of International Affairs. And my question is also for you, Ms. Ćapeta. You mentioned in your keynote that the meaning of values in Article 2 are differently weighted between the EU and the member states at national level, and therefore the Court of Justice perhaps prefers not to make any groundbreaking decisions based in a break of values as it relates to Article 2, except if fundamental liberal values are broken. And here my question is, with the steady rise in nationalism and populism that we're seeing across EU member states in Germany and Italy and France, and the associated fundamental clash in liberal values, do you think that we will be seeing the Court of Justice having to make more decisions based on values as it links to Article 2 on a constitutional level in the future? Yes, thank you.
Thank you. So maybe one last question in this round. Yes, please.
Thank you so much. I study law at the HU and I work as a research assistant at the Institute for European Politics. I was going to press you on something that you said during the first part of your keynote, which is that in the aftermath of Van Gent and Loos, the contestations among member states confirmed the existence of EU constitutionalism. And this line of thought reminded me a lot of the discourse around international law that we saw after the US intervention/invasion in Venezuela, which is that people compared the watershed nature of the moment to the US invasion of the Iraq, that essentially the US no longer pretended to uphold international law and just ignored the terms. So for me personally, I always wonder if the conclusion from contestations affirm existence are not a little bit too easy and a bit too quick. And if we confirm it to what happened in the US, whether you could think of a watershed moment in the EU that would also entail the, let's say, the non-existence of EU constitutionalism.
Thank you. Well, that seems enough for now. So do you want to answer, Tamara?
Sure. Yeah. Sorry, I still didn't even have time to write down the questions, not to think about them. Cases against the EU institutions. I don't exactly know whether you asked me whether do I predict that in the future the court is going to take seriously that institutions are also submitted to fundamental rights or values. Well, I think that it will, and it already does, but maybe the cases are now coming more and more. So the Frontex case was the start, no? And we need to get cases to be able to say anything. I am not going to predict, not even try to predict what the court is going to say in Parliament v. Commission, because I don't know anything more than any of you, you know. The deliberations are happening behind the closed doors, so I know nothing more about the sentence in the Danish case than you do. I can speculate just in the same way. But, you know, the court obviously is aware that, of course the court knows that the institutions are submitted to fundamental rights, and when it comes to institutions it is much easier because you don't have to prove that we are within the scope of the application of EU law. So it is much easier for the court to say, yes, this is the job for us, because who else is going to do judicial review of European institutions if not the Court of Justice? When it is member states, then we can have the problem with the vertical division of powers and ask, why should the Court of Justice do that? Let's leave it to the domestic constitutions. But with the EU institutions, and that is KSKD case in a way, it is the Court of Justice who actually can only properly do this kind of judicial review. Then, of course, the question might be, and there was a question in the past in academia, whether the court is more lenient towards the liability of institutions and the EU in that respect, and the member states. There was a lot of criticism about that, but that was some time ago, and I cannot now answer you about that. I don't see that the court would go that way. But, yeah, that's my best guess. Yeah, raising nationalism, and if the court accepts that the values are justiciable, then would the court have more job to do? Well, it depends on how the justiciability of values will be construed. I mean, yes, obviously, if the case comes to the court, which involves real breach of values, and the court accepts that the court can talk about values, then the court would have to get involved in it. Which is why I said that probably the court should go very carefully about Article 2 and say that this is only about the really, let's say, the situations which you can see as revolution in relation to a concept of governance, no? So if this is in danger, then the Court of Justice as a constitutional court defending that constitution cannot, if it gets the case, do anything else but defend the values, no? But that is why, you know, it is very difficult to say which kind of this kind of conflicts are beyond the red lines or above the red lines. And then I have to add something else. If they are above the red lines and that societies change in the constituent parts of the European Union, then probably either European Union has to disappear or change as well. But then it is just not be the same constitutional, the union with the same constitutional nature as the one that we have today. And this is simply not going to be the same constitutional court. So I do not say, to go to Anna's question about, you know, is this for the court or should this be for the society? Yes, I mean, if the society really changes that much, then what is the court to stop such a change of society? What I just want to say is that then we don't have European Union anymore as we had it up to now, which, you know, who knows what the future brings. This is not, of course, impossible, but this is not something that the Court of Justice as a constitutional court bound by this constitution that we have now can defend, okay? This is more or less what I would say there. And then there was the question about the contestations at the time on Van Genten laws and now US disregard of international law. And if I understood well your question, the question is whether when the court actually, at those times of Van Genten laws, actually ignored that this is international law and said this is a constitution, that whether that was a problem and whether then the contestations, if they were ignored, were a problem. I would say that there were never real contestations about the court turning the treaties into a constitution. The contestations that were then there were of different kind, in my view. They started with the contestations about the fundamental rights respect, which were very clear contestations. I mean, that was the contestation which existed because there was no fundamental right protections at that time, and the court insisted that what is decided on EU level has primacy over national laws, and it was only logical, you know, that some court, and it was German constitutional court, would react in the way, but we cannot accept that this prevails over our laws and the decisions of our political process that is bound by fundamental rights. So this was a really good contestation that then moved the court to develop the protection of fundamental rights, but it was not a contestation of the constitutionality, constitutional nature of the EU legal order. It was just the contestation, this was not whole. It was a constitutional order that missed something in a way. And then the next of the contestations on the level of the competencies, no ultra-virus contestations, are just the normal contestations that exist everywhere in all federal systems, and so they exist in the European Union, and yeah, and they're also useful. The last round of contestations that we have, which is identity contestations, there might be some more stories about well, not necessarily. We are now, I mean, I'm now talking from the point of view of the Court of Justice, and I think that we have settled these contestations. I know I read what Anna wrote in a recent article, and not necessarily she would agree with me. But what I want to say is all these contestations were not the contestations of the court turning international legal order into constitutional legal order and therefore not respecting international legal order. I would say it was acceptance of the constitutional nature of the EU legal order and then contestations within that, of the parts of it. So I wouldn't compare it necessarily with what is now happening with the US that is starting to disregard the existence of international law. If this is satisfying your what you wanted to ask.
We maybe have time for one or two last questions. I see Dimitri and then Marcus.
Yeah, thank you. Thank you very much. Dimitri Spieker from Humboldt University and the Max Planck Institute in Heidelberg. Tamara, thank you so much for the talk and for coming again to Berlin. We are really honored to have you as a regular guest here. I have one question regarding the consistency of your, let's say, of your argument in Commission v. Hungary. I mean, on the one hand, you say, you develop this idea of a negation approach. You say, okay, Article 2 should only be breached in case of red lines, or should only contain red lines. We should not derive positive, let's say, positive contents from Article 2, and I share that feeling, because obviously that goes then into Anna's direction. If we actually flesh out the standards in Article 2, then we actually might go too far and overstep the function of a court, and even actually be even more activist in that sense. At the same time, however, in Commission v. Hungary, you say that Article 2, together with Article 49, might even contain an obligation for the member states to not only respect the values in Article 2 in a negative sense, so not to breach them, but also to positively promote them, actively. And I mean, yes, it is in Article 49, it says, right, only those member states may accede the Union who respect and promote these values, right? So the notion, you didn't make this up, obviously. But how do you see this? So is there, besides these negative obligations in Article 2, also space for more positive obligations? And what does that actually mean? Would they be justiciable too? And where would that lead us? How is this consistent with your approach?
See, this is the problem. If you cite someone in your speech, they might be in the audience and might ask you about it later. Marcus Jachtenfuchs.
Thank you. I'm now going to do something that I do not like when I'm on the podium. I'm saying I don't know much about your topic, but here's my question. So I'm Marcus Jachtenfuchs. I'm a political scientist at the Hertie School, a professor of European governance. I mean, I very much liked your tableau of the European Constitution, but this is what I do not know much about. But I wonder, isn't there a gap somewhere? And the gap starts by my reading of an article that says we have all the guardians gone. You know, you reminded us that the court depends on cases, and that argument says the Commission doesn't bring enough infringement cases anymore to the court because it's afraid of all kinds of political things. The other argument we heard already there, external relations, security policy is not really covered by court adjudication. You know, the other thing that comes to my mind is increasing number of informal agreements, the role of the European Council. And when I follow the debate on the geopoliticization of the EU, I hear coalitions of the willing, informal arrangements, etc., etc. So my question is, do you agree with the diagnosis there is an existing and perhaps increasing tendency to move outside of the EU constitutions by actors who act within the EU? And what do you think about it? Thank you.
Tamara, you have the last word.
Mm-hmm. Thank you. Sorry, I will forget. Yeah, promotion of values. Well, what I more had in mind there is, you know, that at the moment of accession of member states in last two waves, including my country, we were not necessarily yet there with the concept of liberal democracy. So in a way, yeah, I mean, in a way, promotion means reaching in real life situations of those countries, so in the society, what on the paper and in their laws is there. For example, we were discussing, I said that I actually don't know what is the legal consequence of saying in Commission v. Hungary that Hungary breached Article 2. What do they have to do now? Okay, obviously they have to amend those laws and everything, but they would have to do that anyhow, because when you say they breached values, and I'm saying breaching values means going outside of the concept of liberal democracy, that would mean, oops, now they have to go back to the concept of liberal democracy, so what do they have to do? And there were some people I was discussing with, well, obviously after that, what they have to do the positive campaign saying LGBTI is good, okay? Change the situation in the society. And I actually don't know. And I admit that I don't know, but it is, in a way, the positive effort to keep, as a government, to maintain the society within that concept, but in very broad lines. That's as much as I can say in my defense. So I didn't have that in mind in the sense of, positive actions as the Strasbourg court ask from time to time from states in different fields of human rights violations. But yeah. And this is a very difficult, of course, question, and it maybe has to do also with what Anna asked before, whether it is good that mediation happens at the court and whether it goes out of the court because of this now. Either the actors are not coming to the court because they are afraid of the court, because then the court is going to stop them. And as much as we still believe in the rule of law, if the court says, no, you can't go there, they will not be able to go there anymore. And that might be the reason why sometimes Commission will not want to bring something to the court. Or the European Parliament, by the way, brought this case only very late against the Commission. They could actually react in the stage before if they really wanted to change something. So that could be the one reason. Then when you say Commission is bringing maybe not enough cases, and obviously for Poland that was at a certain moment, there was a lot of criticism. I could also say that maybe Commission is bringing too much sometimes without thinking. Commission with Hungary might be one example, no? Because the Commission came very, very bombastically with Article 2, and then they actually withdrew quite a lot during the hearing. But I had, for example, recently the case in which Commission sued Slovakia because of discrimination of Roma in that country. And they brought the case to the court, and all the evidence showed that there is really still discrimination of Roma there. So what the court only can do is say, yes, there is discrimination of Roma, Slovakia infringed EU law. In the meantime, Slovakia was doing a lot. Slovakia was trying to defend itself by saying, but we did that and we did that. And Commission accepted, yes, you are doing a lot. So my question is, why did you bring them to the court? Because once they bring them to the court stating that they infringed prohibition of discrimination, the court just looks at the result. This is an obligation of result. If the result is not there, there is infringement. The court does not have any other choice but to say there is infringement, even though we could maybe think, yes, but Slovakia is doing enough. So this is also on the commissions, that the commission has to think about which cases to bring to the court and which cases not to bring to the court. And this had to do with my saying, if it is brought to the court cannot say, sorry, we are not going to decide. But this brings me to maybe an important question which you rose. Maybe there is a time, that the time has come, that the court has to develop some kind of a theory which would allow it when not to decide. So what the Americans call political questions doctrine, on international level, asylum maybe, I don't know, because the world around is becoming such that we need very quick reactions, political reactions, maybe sometimes very difficult political reactions. And these are the situations in which there might be a reason to say, okay, but for now, this is not for the court, because if it comes to the court, then we have to say there is a breach of law, of some law. But if it is not for the court, then we cannot say it. And I have to say that the court, according to my opinion, and I was criticizing the court for that already, the court does it already in international relations by saying that international agreement that the European Union signs do not have direct effect, and that became the rule, the standard. No, they don't have direct effect. What does that mean? It means, no, we are not going to assess compatibility of EU legislation with international agreements that we adopted. And what is this else but the court running away from the responsibility of judicially reviewing in international relations domestic institutions. And yes, I agree with you that the changing geopolitical context might actually force the courts, and this also goes to something that Joanna asked, to maybe think more about what to do with political questions. Because I would say that up to now, even though they mentioned something like political question in KSKD, the court doesn't really have a conscious theory of political questions except through this direct effect in international relations.
Wonderful. So we know what we can ask you back for next year, the political questions theory of EU law. Wonderful. Thank you so much, everyone. At the beginning, we said thank you for braving this strike to come with us today. We're going to reward you with a non-alcoholic drink. So please stay around for that. But before we do that, please give a round of thanks and applause to our wonderful panel and to Tamara Ćapeta for coming to Berlin. Thank you.